edit so you don't have to see all of this. All right, so the uncontested divorce in Texas, things you need to know. So who can file for the uncontested divorce in Texas? It is, like I said, it has to be uncontested as it sounds. So there's agreements in different aspects of your lives. So you have to live in the state of Texas for at least 6 months. So at least one person, the person who's filing, and you have to agree on the reason for the divorce. And if you have children, it gets more complicated. So sometimes you need to agree, and the judge will always look at the best interest of the child or children. You have to discuss all the aspects of your assets, your liabilities. There's an inventory of all your assets and liabilities you have to file with court, and to talk about how you will separate, or who will get what, in terms of those responsibility and benefit. So, okay, so Texas allows divorce based on fault and no fault grounds. So basically, no fault is when the marriage has become insupportable. And that's most of the time, that's what comes into, uncontested, because when there's fault, always, those are contested. And sometimes, unless, the spouses really agree and they don't have to go through the trial or to continue that. Yes, so like I was saying, the uncontested divorce, you have to agree on how to divide all personal property and real estate property, or the outstanding dates, spousal, if there will be alimony or spousal maintenance, child support, child custody. So to be honest, I think in cases where there is a lot of assets to be divided, there are children, minor children. It's advisable to have, for each spouse to have an attorney, even if you come to an agreement, but you have to have your own attorney, and then the other spouse has their own attorney, so that the agreement is where that takes care of each of you, or the interest of each of you, and most importantly, the interest of the children. So the uncontested divorces that commonly take place is when there's no children involved, and maybe the marriage is young, or you haven't been married for a while. But it doesn't mean that those who file for uncontested divorce and they have been married for a long time and they have children, and just they want to agree to separate amicably, they can always do this uncontested divorce. So when the divorce is filed, the person who files for the divorce, you live in Texas, you've been in Texas for 6 months, you have resided in your county for 90 days, you file for the divorce. So you file in court, but you have to serve the other party. So if they are not with you, so if you live together, or if it's uncontested and something you agreed upon, you can have your spouse file or sign or get an affidavit of a waiver of service. That way to know, okay, they already know. So yeah, and you will always, a waiver of service, like I said, yeah. And you can read all of this, so I don't want to take much of your time. So if the spouse hasn't signed, right, so okay, right. So after, if you serve your spouse, in case they don't want to sign the waiver, or they don't want to, or in the case of the spouse you have to serve has moved out and you have to serve them where they are, you use a hand delivery or a private process server, and the service, proof of service, has to be filed with the clerk, the court's clerk. And then after that, you have to count 20 days for the spouse to file a response to your filing. So they have to file a response. If they don't file, you have to wait another 10 days, and then you can file a default judgment, requesting the judge for the default judgment. So in these cases, really, everything has to be followed through. So sometimes I'll give you an example. The proof of service, I served someone for my client who served them. They were out of state, and then the proof of the private server returned a document, or proof of service, that was not notarized and signed, and the judge, on our day of hearing to get the default judgment, the judge refused and said, okay, it wasn't proper service. So we had to serve to correct the service and get the paper, the document corrected. So it is very important to know, okay, when you file for the divorce, your attorney, and then you use the proper, if you're using outside of Texas, you use a proper private server, and they have to follow each county. Each county has their own local rules you have to go through to follow, okay? So after 60 days of waiting, again, in Texas, they give you 60 days before the judge, they can schedule a hearing for the final judgment, the final decree of the divorce, unless, again, you want to file a motion for default judgment beforehand. And in that case, I told you, you really have to count the days. So the 20 days to wait. After 20 days, then within 10 days, you can file for the default judgment. But, in my experience, judges still may opt to wait for 60 days. And you have to know, even if you can file a default judgment, right? A motion for default judgment, the spouse, within the 60-day waiting period, can still file a response. So you have to always check. They have to serve you, of course, but you have to know that within the 60 days, even if there is no response, after 20 days of filing for serving your spouse, and then after 10 days waiting, after the service, the service has been filed with the court, proof of service has been filed with the court, you have to know that, okay, even if you can file a motion for default judgment, the 60-day period, within the 60-day period, beginning the whole process, the spouse can always file a response, and then, you have to wait for the 60 days for the judge, then to go to court and to get a judge to decide on a divorce. So I have also to tell you something in case the spouse does not live in Texas, what happens is the judge may just give you what is called a status divorce. So if you let's say you live in Texas, but your spouse lives in another state, in that case, the judge, where you still need to file, the inventory, or the assets, or the liabilities, or the debts, or everything. You still need to file it. In case you don't know what your other spouse has been to, in case of you have been separate for a while, then you just put non-applicable. But even if you file those documents, the judge will say that they will not, in your final proposed divorce decree, the judge will take out all the real estate and property sharing and all that, and then they will only want to rule on status divorce, because the person does not live in Texas, so they don't have jurisdiction over the person unless the spouse file a response. This is in the case of default judgment. So in the case of default judgment, if you file and serve your spouse fails to respond, then the judge will only rule on the status divorce, meaning they will declare you divorced, but they will not really rule on on whether or not your property and all your assets or your liabilities, in case of children, that's not another case. they will only rule on the status divorce. That's what's called status divorce. So again, I just wanted to talk to you about this, the uncontested divorce in Texas. Sometimes it's a straightforward case, and and that it may be a solution for people who don't, they've been married, they don't really want to stay together, and they don't want to spend a lot of money on lawyers and trials. And I will also tell you that even in contested divorces, most judges advise the spouses to go through mediation and then kind of come with some type of agreement, even if some of the matters or issues will not be agreed upon, but they will agree on some or most of the issues. And then, that way you won't spend months in court. As you know, some divorces take years to resolve, especially for those who have a lot to you know to contest. All right, thank you so much for I'll stop sharing, and I'm so sorry again for the glitch in the technology. I hope you have a wonderful afternoon, weekend, and if you have any questions, please go ahead and comment and share, or if you feel this is useful. Thank you.